I have never owned real property in the United States. Wait, so hold the fuck. Wait, what the fuck? So we have new documents. There's it looks like copies. There's a proposed order copy, and then the actual motion to dismiss that was filed by Iron Mace today, filed 6/22/23 today, sometime this afternoon or this morning, I guess. And then, you know, obviously it had to get in from Greenberg Glusker's office with a copy of the proposed order for the judge to sign, as well as it looks like there was an assignment form, a consent form for the attorneys to sign, agreeing that the judge, the magistrate judge, Michelle Peterson, who heard the case originally, would be included as the magistrate judge for the trial. So case has been assigned to Magistrate Judge Michelle Peterson for all purposes, including trial, final entry of judgment, and direct review by the Ninth Circuit Court of Appeals. So consent to a magistrate judge is voluntary. Any party may decline consent. So I don't know if they're going to sign this or not, but this is a copy of the consent form. I don't know if it's customary to not want the originating magistrate or to want them. I have no idea, but I don't see why they wouldn't keep her on. But in the meantime, this has been put before the judge as a motion to dismiss from Iron Mace's attorneys. And then we're going to look and see what they have to say, I guess. Okay, so here's the table of contents, statement of facts, argument, and conclusion. And then these are the cited cases. And maybe what we'll do is I'll do a follow-up video where we look into this and what cases they're citing on each one of these pages. This is a lawsuit brought by a Korean video game publisher against 2 Korean nationals and their Korean startup. Oh, interesting angle, if that's the way that they're going with this. Plaintiff Nexon Korea claims that 2 former employees, Joo-Hin Choi and Terrence Sangwa Park, left Nexon to form a competing company, Iron Mace Company Limited, which they unlawfully used Nexon's trade secrets and infringed on its copyrights to create Iron Mace's flagship game, Dark and Darker. Nexon has no evidence to support these allegations, which is no surprise given that they are a complete fiction. The truth is that Iron Mace and its developers used their tremendous skill and creativity to develop Dark and Darker entirely on their own without using any of Nexon's proprietary material to accomplish that feat. Now, again, as I said in the original complaint letter, all of this will have an extreme amount of bias on it, right? Anytime that these attorneys write up complaint letters or responses, they're going to be like just this side of what is legal. So, of course, they're going to try and spin this in whatever way that they possibly can to make it sound as though, you know, their argument is the right one. And then, obviously, if there's a trial, it goes to trial, and then there's discovery and all these other things. So we'll have to see if this goes to trial or not. I don't know if the judge is going to grant this or not based on like what we're reading and so far, but we'll see if there's any merit to this. But this motion is not about proving that Nexon's claims are meritless. Iron Mace, Choi, and Park are already doing that in litigation that is ongoing in Korea, which is true. Because right now, as we saw in yesterday's video, there's a news article that covered that, where there's 5,000 pages submitted by each party, plus laptops and everything, where they are going through and looking at the code and everything else. And there's basically been put on recess for a month while a third party looks through everything and makes a determination as to whether or not anything was actually stolen from Nexon. So that is ongoing at the moment. Indeed, Nexon has already filed a motion for preliminary injunction against each of the defendants in Korea, raising the same claims and seeking the same relief as it does from this court. True. The parties have already engaged in multiple evidentiary hearings in Korean District Court, presenting thousands of pages of documents and witness testimony, all of which is in Korean, naturally. There, a Korean panel of judges will evaluate the evidence, including Iron Mace's internal notes and source code showing exactly how Dark and Darker was created, and will undoubtedly see Nexon's claims for the anti-competitive smokescreen that they are. And that court is where this dispute should be resolved, not here in Washington. So that's the angle that they're trying to pull right now. Because there is a proceeding against Iron Mace in Korea ongoing right now that is further ahead than the proceedings that are going on in the United States right now, they're basically saying they shouldn't be trying this case in the United States because it's being pursued in Korea. Now, here's the interesting part. the doctrine that they're citing, like this is typically something that, like, from what I have read on other cases where this kind of stuff is going on, like there's cases that have already been cited with serving people outside of the country when they have related cases. If there's a case ongoing that's further ahead in like the home country of the case, like if there's multiple cases in multiple countries and the home country is trying this case like right now, typically the United States courts just like go, okay, well, that's going on in your country right now, so we're just going to wait and see what happens. Because if you think about it, logically speaking, in Korea, if they are found guilty or if an injunction is placed upon Iron Mace in Korea and it forces them to stop production, then what's the point of having a court case in the United States? If they're found guilty and they have to stop, then they have to stop. They'd have to change countries in order to be able to continue like developing the game. You see what I'm saying? And then it would have to get heard in like whatever country they ended up residing in. So because their residence is in Korea,
good.
You know what I'm saying?
26 months of Mises.
Hell yeah, Kushi. Because it's being tried right now in Korea for this exact same issue. If the Korean court found them guilty, they'd have to stop, and there's no point in bothering to talk about it in the U.S. at all. Because if they can't work on the project in Korea, then it automatically becomes a moot deal. Right? So what they're trying to do, and like even though I've gotten like just this far, what they're trying to do is argue that because it's being set up already in Korea, that trying it in the United States is a waste of time, which is what they're I guarantee you, like that's where they're going with this. The court has broad authority to decline to exercise jurisdiction in favor of litigation in a more convenient foreign forum. The facts here overwhelmingly support allowing the parties' dispute to play out in Korea. First, and dispositively, the parties are subject to contractual forum selection clauses providing for exclusive jurisdiction in Korean district court. Second, there is no question that Korea is an adequate alternative forum to hear this dispute. As mentioned, there is active litigation in Korea right now between the same parties over these exact claims. Third, both the private and public interest factors overwhelmingly point to Korea as the only sensible place to hear this dispute. The parties are all Korean. All of the evidence is located in Korea and written in Korean, and the relevant witnesses all reside in Korea and speak Korean. All of the conduct giving rise to Nexon's claims happened in Korea and has no connection to Washington. Well, that's not really true. I mean, the majority of the business that would have been conducted in the United States based on player records is that it's Steam. That's why they're talking about it or trying to talk about it in Washington, because of Steam and the amount of money that would flow through Steam. That's why they've bothered to bring the U.S. into this at all, because they're following the money trail. So I don't know that, like, this really isn't that true. The conduct giving rise to claims happening in Korea has no connection to Washington. Like, while the claim is in Korea or whatever, like, they're just following the money trail. So that's absolutely valid. There's no need to burden this court with a complex extraterritorial dispute, particularly when a parallel action is already proceeding in the party's home forum. It is clear that Nexon is pushing forward with litigation in two countries simply because it has the resources to do so and believe it can grind the defendants down by multiplying their legal fees. Nexon should not be allowed to misuse the United States judicial system in this manner. The court should exercise its authority to dismiss this lawsuit, allowing the parties' dispute to proceed in Korea where it belongs. Interesting. Okay, and then they go through the facts. Who is who, what's what, what's being created. Worked for Nexon in game development. Choi and Park signed a written agreement with Nexon. Declaration of Yungjun Jeon Declaration. That must be like how it's the way that it's worded in Korean. These employment agreements, which are in Korean, were drafted by Nexon and presented to Choi and Park for signature as is. Each contained a forum selection clause providing that for any dispute relating to the agreement, the competent court of jurisdiction shall be the sole district court. Choi and Park also signed documents called Acknowledgement about Company IP, Confirmation of Rights regarding work-related intellectual property. These documents were drafted by Nexon and presented to Choi and Park for signature as is. Each of these documents, which are also in Korean, contain forum selection clause, providing in the event of a dispute relating to the agreement that sole central district court shall have exclusive jurisdiction of competence for the first instance. While at Nexon, both Choi and Park worked on a development project referred to as the P3 project. So, like, while they're trying to make a compelling argument here, what I will say is that this is based on, like, individuals and individuals signing stuff about their involvement, individual involvement in IP. But even though they are in court now, like, even though Nexon is suing Iron Mace over this whole thing in Korean court too, they do name them both as individuals. So, like, this could swing either way, I think, argumentatively. Because they are, like, they're naming Iron Mace and Terry and SDF in this lawsuit. So if they're trying to invoke these, and there's already language saying that they're supposed to stay in Korea to get it figured out, it might actually be a detriment to them to have tried to, like, combine all of these things into one big case instead of breaking them off into singular ones. It might, I mean, maybe this ends up being the thing that prevents them from being able to have it heard in the US at all. I don't know. While at Nexon, both Choi and Park worked on a development project referred to Project P3. Video games submitted by other studios, PUBG Battlegrounds, and Fortnite. It was intended to be a first-person battle royale game, but with medieval fantasy settings. P3 project was under development. Project primarily staffed with only 10 people, and development went slowly as a result. Choi and Park left. At the time they left, the P3 project had not crystallized into an actual playable game. It was nowhere near being released. Choi, and this is based on a Choi declaration, it looks like. Nexon has accused Choi of taking Nexon trade secrets. Choi did not retain any such information. This is categorically false. This is, again, a Choi declaration. If this gets dismissed, can they not use it again? No, if it gets dismissed, they can definitely go back. If it got dismissed on for reasons of being heard in Korea, they could absolutely retry it. Like let's say Korean court says Iron Mace not guilty. Nexon could still try to sue Iron Mace in the U.S. over copyright claims and drag them through court again. However, if Iron Mace found not guilty after looking over everything that they looked over in Korean court, like they would absolutely, like their attorneys would absolutely kind of like appeal to authority, even though that's kind of like a shitty way to do it. But they would absolutely appeal and say like, well, in Korea, this already happened and they already got found not guilty. That's kind of like a solid feather in the cap, you know? Like all the research and everything that had been done, you know, looking into the source code and all, if that's how it came out, I'm sure that they would say, or definitely they would argue that in their response, and they would just file another motion to dismiss based on what happened in Korea, if that's what happened. Iron Mace spent the better part of 2 years developing a flagship game. One of the core features is its extraction mechanic, something shared with other games in the genre, but not with the contemplated P3 project or any other game Nexon has developed. Wait, what? Hold up. What? Hold on. Now that's different. That is completely fucking different than anything that we have talked about up until this point. So they are claiming that there was never an extraction mechanic in Project P3 or any other Nexon game. Dark and Darker is a first-person extraction game and dungeon crawler with a fantasy setting. One of the core features is its escape mechanic, something shared with other games in the genre, but not with the contemplated P3 project or any other game Nexon has developed. According to Choi, and Choi was the creative director in both projects. So there was no extraction mechanic associated with it at all. Like the dungeon crawler was just going to be planned to be a BR. That's interesting. Iron Mace has devoted significant time and resources to building the game, hiring 20 skilled veteran game designers, programmers, artists. Iron Mace designed Dark and Darker from scratch. It has not used any of Nexon's intellectual property or other confidential material to develop it. As discussed in greater detail below, Nexon has accused Iron Mace as well as Choi and Park personally of infringing and misappropriating intellectual property and creating Dark and Darker. Overwhelming evidence to show that's false, according to Iron Mace, and that Dark and Darker was developed independently in a manner that infringes none of Nexon's rights. Because of how and where Dark and Darker was developed, this evidence is all located in Korea. In particular, throughout the development of Dark and Darker, internal communications among Iron Mace employees occurred almost exclusively in Korean. Emails within the team are similarly in Korean, as are notes and records concerning the internal team strategy meetings and the progress in developing the game. That is because Iron Mace's full-time employees, a little more than 30, all live in Korea. So they've actually increased their staff size since all this started. They were at 22 hands to keyboard. Now they're at nearly 30. More than 30. Nearly all of the Iron Mace team has limited familiarity with English. And I think that's true. I think the only one that's truly fluent in English, there's two guys. I think it's Terry and what's his face? Shit. Why is their name escaping me? Chat, help me out. Grayson, yeah. I think it's Grayson and Terry are the ones that are pretty fluent in English. Terry's absolutely fluent in English. He's like all the way fluent in English. He doesn't even have a Korean accent when he speaks English. When he wants to sound like an American, he does. Which is crazy. But yeah. So like to this effect though, if they tried to try all of this with all of the evidence and everything in the United States, that means that between the two companies and all of their evidence, you have 10,000 pages worth of evidence and testimony and all kinds of other things that need to all be translated into English. And it's not like they're just going to hit up Google Translate. That shit will take forever. Forever. SDF isn't really fluent in English. He said multiple times. Like, he speaks English, but like he says multiple times over that his English is not very good. The same is true for the source code and programming notes that show how Dark and Darker was built. Those are all in Korean. The computer systems used to develop the game are physically located in Iron Mace's Korean office, and its servers were located in Korea throughout development until early 2023 when they were moved to a cloud hosting solution. All of the parties to this lawsuit, Nexon, Iron Mace, Choi, and Park, are already litigating an identical dispute in the Korean court system. Most notably, on April 14th, 2023, Nexon filed a lawsuit against Iron Mace, Choi, and Park in the Suwon District Court in Korea. So this is why I say, like, this wasn't something that was getting an awful lot of traction, at least over here, because while there was a lawsuit that's been going on between Nexon and SDF, even saying as much from the attorneys when they were filing stuff and sending letters off to Valve and everything, like, the only lawsuit that existed was against SDF. As of mid-April, they filed a suit against Iron Mace, and it probably took a while to get heard, which is why none of us had really been hearing anything about it, which asserts claims of trade secret misappropriation and copyright infringement against each of the defendants. It's in that Korean proceeding, Nexon seeks a preliminary injunction restraining Iron Mace from publishing or distributing Dark and Darker. In addition, Iron Mace has filed its own lawsuit against Nexon in the same Korean court seeking a judicial declaration that Dark and Darker does not infringe on anything Nexon may have in its so-called P3 game. In connection with that proceeding, Iron Mace has filed an application for preliminary injunction against business obstruction, asking that Nexon be ordered to withdraw the takedown notice it sent to Valve under the United States DMCA. All of the parties have been served and have appeared in the foregoing Korean proceedings, which is true, which are currently in active litigation in Korea, which is also true. The parties have had multiple evidentiary proceedings before the Korean court and have already filed thousands of pages of briefing and evidence in connection with their disputes, all of which is in Korean. Nexon has submitted copies of Nexon employment agreements with Choi and Park, copies of Nexon's acknowledgement about company IP, computer logs, and internal data from Nexon, emails, written witness statements, text messages, and transcripts of oral conversations, all of which is in Korean. Okay, under the doctrine, a district court may decline to exercise jurisdiction in favor of litigation in a more convenient foreign forum. This is what I was talking about at the very start. Because this is already going on in Korea, and they're further ahead in the court case. And there have been cases that I have read that got tossed initially because of this going on in, like, the home country. The traditional forum analysis examines whether an adequate alternative forum exists, 1, whether the balance of private and public interest factors favors dismissal, meaning in the United States. In a typical case, the court will decide whether, on balance, a transfer would serve the convenience of parties and witnesses and otherwise promote the interest of justice. However, whereas here, the parties are subject to a forum selection clause, one which was drafted by the plaintiff, Nexon's choice of forum merits no weight, and the plaintiff bears the burden of establishing that transfer to the forum for which the parties bargained is unwarranted. Only under extraordinary circumstances should a court decline to enforce a valid forum selection clause, according to Sun versus Cow. So that must have been one of the cited parts. Oh no, sorry, citing Atlanta Marine Company, 571 U.S. Only under extraordinary circumstances should a court decline to enforce a valid forum selection clause. Interesting. Any presumption that might otherwise be given to Nexon's choice of forum already applies with less force, given that Nexon is a Korean plaintiff and Washington is not its home forum. Which is then they cite Piper Aircraft, because the central purpose of any forum non-convenience inquiry is to ensure that the trial is convenient. A foreign plaintiff choice deserves less defense or less deference. Interesting. Forum selection clauses are presumptively valid. The party challenging the clause bears a heavy burden of proof and must clearly show that the enforcement would be unreasonable and unjust, or that the clause was invalid for such reasons as fraud or overreaching. Here, Nexon cannot rebut the presumptive validity of Korean forum selection clauses that Nexon itself drafted and presented to its employees to sign as is. So, this is actually, this is, I mean, they could be kind of fucked in the U.S., man. Like, this might not actually get heard in U.S. court. I don't know if the judge would keep this. I think she might toss it. I mean, I'm not a lawyer, right? I'm not a lawyer. I say this every fucking video. I'm not a lawyer. I'm not sitting in the court. I'm obviously not a fucking court magistrate. But all of that being said, it makes logical sense. If I'm the party that says these guys are bad, I'm taking them to court, and I take them to court in a country way the fuck over there, and I take them to a court that's next door to my house, and the country way the fuck over there, the other court doesn't speak the same language that I do, and all of my evidence is in my home language, and the people that I'm suing signed documents that I created and had them sign as a tenet of their employment. I created documents that I made them sign that said, if there's any disputes or if we need to bitch to each other about something and have a third party listen to us and figure out who's right, that's going to be done in my court that's right next door to my house. We're all agreeing that that's what's going to happen. I can't just suddenly turn around and be like, well, I think I want to go over there too. You know, because really all you're doing is making the people that are trying to defend themselves have to do both, right? Like, you defend yourself at the next door court, but then I have to go all the way over there and defend myself too at my own expense, even though we're arguing about the same exact shit in both places, if only because the employer is saying that the employees can't have business not only next door to their own house, but also way the fuck over there too at the same time. So they might actually have grounds to have this thing tossed, man. It's not even this isn't even hopium. This isn't even hopium. This is just logical. And there's a ton of case precedent that comes before this where the multiple cases have been tossed out for this exact reason, because cases were already being heard at home for the exact same case, on home turf, you know? The practical result is that the forum selection clauses will almost always control. And Nexon, it would be different, if, how can I put this? If Nexon decided that they were going to sue SDF as a person individually, and then sue Terry as a person individually for being involved, or Terry as an accessory to SDF, and they were separate court cases, that would be one thing. Or if they had those two separate court cases, and then they sued Iron Mace in the United States as a separate deal, right? Yo, Cryo, thanks for the 16 months, man. I think it would be different if they were disconnected. Right? If SDF and Terry were being sued in Korea for their involvement with the data theft or whatever that Nexon says that they're doing, and then they sued Iron Mace for trying to do business in the United States under DMCA and DTSA, that would probably have been because they were pulled apart, it probably would have been a different deal. But because they're naming all three entities in the same suits in both countries at the same time, and Korea's further ahead. Yeah, not looking good. They filed after, it looks like they filed the suit after they filed the one in the United States, but it's being heard earlier than the one that was filed in the United States. As discussed below, both the traditional and Atlantic marine tests for forum nonconvenience are easily satisfied in this case. Korea is an adequate alternative forum, which they already had agreed on in the signed documents. The balance of private factors is deemed established in favor of litigation in Korea by virtue of the forum selection clause, and otherwise demonstrates that Korea is the more convenient forum. And this is not an extraordinary case in which the public interest factors clearly disfavor dismissal, but to the contrary, they weigh strongly in favor of dismissal. I have to agree with that. Like, again, not a lawyer, not a judge, but I have to agree with that. Therefore, this case should be dismissed in favor of Korean proceedings that are already ongoing between parties involving the very same dispute. Like, I'll just bring it back to the pile of evidence and documentation. They've already said in the news article from the video yesterday, between the two parties, there were 5,000 pages of evidence each in Korean that the Korean court needs a month to go over, to then have to take all of that evidence and then translate it all into English would take forever. Like, for fucking ever. It would be horrendous to try and get all that translated to English. And like I said, there's no way in hell they're going to trust something like Google Translate to do it all. It's all going to have to be transcribed by, I don't know, some fucking buddy to do it all. And the man hours and amount of labor and the time would be absurd. Absolutely absurd. I think Nexon kind of shot themselves in the foot by trying to lump everybody together at once. And by trying it in both countries at the same time. Because when they originally filed this, they argued that the reason why they needed to file, when they filed the DMCA claim, they argued that it was because of all of the business was being done. And then when the letters came out for Iron Mace to be, for Dark and Darker to be relisted on Steam, like their whole argument was that like this isn't being heard, like nothing's being heard in Korea. It's only a case against an individual, which at the time was true. But now they've actually filed a full-on lawsuit, like in mid-April. Yeah. And we know as of yesterday that no motions were granted. Like there was no injunction granted. Neither party was forced to stop doing anything, and like business continues. So like I said, like for Iron Mace, that's a W. And I know that there were a lot of people in the comments that said like that's not a win, that's just normal court procedure or whatever. Okay, fine. But if I have a small business and another business is suing me, and they try to get a court to order me to stop doing business so I can't continue working on my product, and the court goes, I don't feel like it, I'm going home and drinking a fucking beer. I don't know about you all, but if that means I get to go to work the next day, that's a fucking win. Like, I don't give a shit who you are. That's a win. I'm going to go home and I'm going to celebrate. So, like, people being like, it's normal court process doesn't mean anything. No, it's a fucking W. As an alternative forum is available where the defendant is amenable to service of process and adequate when it provides the plaintiff with some remedy for his wrong, the Ninth Circuit Court has recognized this test is easy to pass. It's only in rare circumstances that the available and adequate forum requirement is not met. The fact that substantive law in the alternative forum may be less favorable is irrelevant unless the remedy provided is so clearly inadequate or unsatisfactory that it is no remedy at all. So what they're basically trying to say is that the Korean court would have to be so absurdly shitty to figure this whole thing out that it must then move to a different place, meaning the United States. But the argument here is that that can't possibly be true because it's already ongoing in Korea for this exact same case, and all of the evidence is in Korean, and there's signed documentation saying that the parties agreed that they were going to hear this in Korean court, which they're already doing. So why are they bothering in the U.S.? Here, this low bar is easily satisfied as there can be no dispute that Korea is an adequate alternative forum. Iron Mace is a Korean corporation with its principal place of business in Korea, and Choi and Park are both permanent Korean residents, which is true. Park has dual citizenship. He has a residence in California and a residence in Korea, but Choi just lives in Korea. Not only are Iron Mace, Choi, and Park therefore all amenable to service of process in Korea, but the parties are already litigating this dispute in that country. Nexon has filed a pending application for preliminary injunction in Korea against each of the defendants, which asserts the same copyright infringement and misappropriation of trade secret claims and seeks the same type of relief as it does in this action, namely that Iron Mace refrain from making its video game available to the public. All of the defendants have appeared and are actively contesting Nexon's claims in the Korean action, which has already been the subject of several court hearings. I mean, that's kind of like the letter. They're basically like they were shown like, all right, well, if you're going to try to invoke this as like a dismissal, you have to meet these bullet points. And they kind of just went, okay, check 1, check 2. Like, there you go. Like, this took me all of 3 minutes. Korea has a sophisticated copyright regime, which provides copyright owners with a range of remedies, including preliminary injunctive relief, permanent injunctive relief, monetary damages, and declaratory relief. So now they're trying to say that the Korean court has a robust enough legal system, depending on any and all punishments that would be doled out as a result. It has like a graduated system that is robust enough to be able to adequately penalize if anybody was found to be wrong. Monetary damages may be recovered based on the copyright owner's lost profits or the infringer's profits gained from the infringement. A reasonable royalty rate that the copyright owner could have received if the infringing conduct had been properly licensed, or any other reasonable calculation of damages in the discretion of the court. The Korean Copyright Act also provides for statutory damages, where a work was registered prior to the infringement, which may be up to 10 million Korean won, or up to 50 million in the case of intentional infringement. As with other civil litigation in Korea, the prevailing party may recover its attorney's fees and costs. So, it sounds like it kind of covers the bases, right? Korea is a member of the Berne Convention for the Protection of Literary and Artistic Works, and Korean courts may apply the copyright laws of other countries where applicable to the allegedly infringing conduct. As the Ninth Circuit recognized in Creative Technology Limited versus Aztec Systems, any territorial limitations on the scope of the United States copyright law do not preclude application of the forum nonconvenience doctrine merely because a foreign owner alleges copyright violations occurring within the United States. So what they're basically saying is our law doesn't supersede their law just because our law exists. United States copyright interests, then by shutting all... Okay, hold on. We are unable to conceive of a more effective means of protecting the plaintiff's United States copyright interests than by shutting off the pipeline of infringing goods at the source. Meaning, like, there's copyright infringement in Korea. A company gets found of copyright infringement. They have a judgment placed against them. Why then relitigate everything in the United States if there's already, a relatively well-recognized court system that found them guilty? Like, why would we, go do this all over again instead of just going like, well, that court seems like it's pretty good and they figured that out. So what are we arguing? In Korea, trade secrets are governed by the Unfair Competition Prevention and Trade Secrets Protection Act, UCPA. As with Korean copyright law, plaintiff under the UCPA may obtain range of remedies, including injunctive relief, compensatory damages, which may be calculated based on the plaintiff's lost profits, infringer's profits, reasonable royalty rate, et cetera, or any other reasonable amount determined by the court. So the first was copyright, and then we have protection of trade secrets. Korea also affords Nexon procedural safeguards comparable to those available in the United States, including the right to an independent, impartial, and fair decision in accordance with the law, the right for all parties to be heard, and the right to a fair trial. In finding Korea to be an adequate alternative forum under these circumstances, this court would be joining many other courts holding the same. Korea held. So here's a case right here: Primacy Engineering Inc. versus San Engineering. Korea held to be an adequate alternative forum in case involving alleged misappropriation of trade secrets, where plaintiff had already sued defendants in that country, asserting the same kinds of claims and seeking the same kind of relief as it does in this action. The South Korean action is proof that there is an alternative forum for plaintiff's claims. There you go. Because Korea's home base. Because defendant is amenable to service in Korea and because Korea provides a remedy for plaintiff's claims, the court finds Korea to be an adequate alternative forum. So they're basically listing a bunch of cases. There's 1, 2, there's a third case that they're citing saying like, the court says this is all good. This is a good place. So they're basically just reiterating over and over again based on all of these precedent cases that they got tossed and everybody said, go to Korea and figure it out. As there is no legal obstacle to Nexon bringing its claims against defendants in Korea, the first threshold factor for dismissal is easily satisfied. Korean Forum Selection Clause, parties dispute. In Atlantic Marine, the Supreme Court held that the existence of a forum selection clause means that the balance of private interest factors deemed to weigh in favor of dismissal is a matter of law. A court must deem the private interest factors to weigh entirely in favor of the pre-selected forum where there is a forum selection clause. When parties agree, so here you go. This is Supreme Court decision right here. U.S. Supreme Court. When parties agree to a forum selection clause, meaning the contract that they signed that said disputes would be handled in Korea, right? Like that's what they signed, something when they got hired that said that any dispute would be heard in a Korean court. So when they agree, which they did, they waive the right to challenge the pre-selected forum as inconvenient or less convenient for themselves or their witnesses or for their pursuit of the litigation. So they can't just cherry pick where they're going to go have it heard if they already agreed this is where we're going to have it heard. Here, Nexon's complaint specifically relies on the fact that Nexon requires its employees to sign an acknowledgement about work-related intellectual property. Pursuant to the acknowledgement about a company IP, any intellectual property rights in the company work product created by Nexon employees during the course of their employment originate from and are vested in Nexon. Moreover, Nexon employees are prohibited from using or recreating any content that is similar or the same as the work-related inventions made in Nexon, even after the employees leave Nexon and join another employer. Nexon alleges that the defendants Choi and Park both signed and are bound by this agreement. They did in their own complaint. In their originating complaint, they wrote that like chapter and verse that they signed these agreements and they put dates on them. Nexon also alleges that it enters into an employment salary agreement that prohibits its employees without Nexon's authorization from disclosing to a third party the company's trade secrets or any information acquired during the course of their employment. Again, from their complaint. Nexon further alleges that Choi and Park signed the employment agreement. As discussed above, both the acknowledgement about company IP and the employment agreement contain broad and mandatory forum selection clauses that provide for disputes relating to the agreements to be heard exclusively in Korea. Nexon's complaint alleges that Choi and Park are former employees who, in breach of their obligations to Nexon, stole source code, audiovisual, and other materials to develop a substantially similar video game called Dark and Darker that they seek to distribute through their newly formed company, Iron Mace. While they are completely false, these allegations and claims on which they're based relate directly to the subject of the acknowledgement about company IP and employment agreement, obviously, containing the forum selection clause at issue, namely the alleged use of content that is similar or the same as the work-related inventions made at Nexon, which is like they quoted that piece saying that there's actually something in here saying that if you generate content that is similar or the same and there's a dispute, that dispute gets heard in Korea. The alleged discourse of the company's trade secrets or any information acquired during the course of defendant's employment. So infringement of copyright and infringement of trade secrets. Both of those had wording that said you have this heard in Korea. I think that the judge is going to toss this. I think she's going to grant this. I think she's going to grant the motion. Because the forum selection clauses broadly encompass disputes relating to the agreements at issue. And actually, if they put a copy in here for a proposed order, this is usually done, like, here's the signature page, right? This is usually done, like, it'll probably end up having a response made by, somebody else. Maybe they put something in writing saying, like, no, this is a bad idea. Which I'm actually super interested to see what the plaintiff will end up saying in response to this. But because the forum selection clauses broadly encompass disputes relating to the agreements at issue, as opposed to those simply arising out of such agreements, the provisions squarely apply to this dispute. And then they cite another case. Clauses that only refer to disputes arising out of a contract apply only to disputes and controversies relating to the interpretation of the contract, while forum selection clauses that include related disputes do not require the contract at issue to be interpreted to apply. There you go. So what they're saying is that there's a dispute. You guys signed a contract that said if we get into a dispute, we're going to litigate this in Korea. Everybody agrees. So it doesn't matter how you interpret the contract one way or the other. It still exists, and we still already agreed that we're going to go and figure this out in Korea. Holding that a forum selection clause that included any action relating to a so now they're talking about the language. A forum selection clause, so the clause about the court that included the verbiage, any action relating to a contract did not require the interpretation of the contract in order to apply. So, like, regardless of how anybody would try to spin this, it literally says any action relating to employment, blah, 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 blah. The words any action mean literally any action. As the Ninth Circuit has explained, a dispute can relate to an argument so long as the dispute references the agreement or has some logical or causal connection to the agreement, which Nexon cited themselves. Nexon brought up the stuff that they signed in their original complaint. So again, I think they kind of shot themselves in the foot. District courts within the Ninth Circuit have regularly found claims for copyright infringement and trade secret misappropriation to be sufficiently related to the parties' contractual relationship for a forum selection clause to apply those claims. In IntelliCAD Consortium versus Suzu, the court held a dispute between the owner of computer source code and a software designer alleging copyright infringement and trade secrets related to the parties' agreement by which the designer was granted access to the copyright owner's source code such that the forum selection clause applied. So like even in this case, it was like super broad, but it was like even though it touched on it, they counted it. Like Nexon's complaint here, the plaintiff's complaint in IntelliCAD contained numerous references to the agreement containing the forum selection clause, and as here, but for the parties' agreement, the defendant would have never had access to the source code at issue in the lawsuit. Meaning that's the only difference. Okay, applying forum selection clause in professional services agreement to copyright infringement claims. So then again, like this is them citing more and more and more related supporting doctrine that already exists in the United States court where like for multiple separate reasons, stuff got tossed and sent back home. So like, this was Beijing, China. Crazy. Finally, even though Iron Mace was not a party to the forum selection clauses between Nexon, Choi, and Park, its alleged conduct is so closely related to the contractual relationship between the parties that the forum selection clause applies to all defendants. So what they're trying to say here is that the documents that were signed were not signed by a representative of Iron Mace. They were signed by individuals that worked at Nexon that now own and operate Iron Mace. But because the other two are roped into this, and the lawsuit is against all three named at the same time, to say that Iron Mace as a company or that the lawsuit itself should be held in multiple different places is kind of dumb, because the case, like there would be no case against Iron Mace if Choi and Park hadn't taken everything that Nexon says that they took and started Iron Mace up. Iron Mace exists because of the originating issues that Nexon has with Park and Choi. Therefore, it's so closely related to the contractual relationship that the contracts that they signed. The whole issue basically hinges on that the parties that the forum selection clause applies to all defendants. So they're trying to say that like Iron Mace has to be part of this, and there's no way to like disjoint the two. And if you can't break them apart, if you can't segregate them from each other, then it should still be heard in Korea, because you guys have already invoked like all of these contract clauses that said that you were going to use the court in Korea. A range of transaction participants, parties, and non-parties should benefit from and be subject to forum selection clauses. So then they're saying like, yep, you should be honoring the forum selection clause in your contract over and over and over again. In this regard, this case is indistinguishable from that of W Boxed Meats Distributors, Inc. versus Parker. In that case, the plaintiff, WBX, alleged that the individual defendants, William and Brian Parker, had unfairly competed with WBX by forming their own company, Double B, using WBX's confidential, proprietary, and trade secret information. As a condition of their employment, the Parkers had entered into various agreements with WBX, which prohibited them from using confidential information outside of the scope of their employment with WBX, or from disclosing such information to other individuals or companies after their employment had ended. Sounds really familiar. WBX alleged that the Parkers left WBX to start a competing business, Double B, allegedly taking confidential information and deleting files belonging to WBX in the process. WBX thereafter filed a lawsuit against the Parkers and Double B in the Western District of Washington. Home base, even. Relying on an Oregon forum selection clause in the parties' employment agreements, the district court dismissed the case under the doctrine of forum nonconvenience, not only as to the Parkers, who were parties to the agreements containing the forum selection clauses, but also to Double B, which was not. Relying on Minetti and Supra, the court held Double B's alleged conduct is closely related to the Parkers' employment agreement. The Parkers allegedly formed Double B with the purpose of competing with WBX in direct defiance of the payment and obligations after termination and competitive activities provisions of the employment agreement. Further, WBX alleges that the Parkers, through Double B, are continuing to misuse WBX's confidential information and trade secrets in direct defiance of the proprietary information obligations provision of the Parkers' employment agreement. In this way, Double B is closely related to the Parkers' employment agreement because the Parkers are allegedly using the corporation to violate the terms therein. Pursuant to Minetti, the forum selection clause binds Double B. Therefore, any claims against Double B within the scope of the forum selection clause must be dismissed in favor of the contractually forum. So they are citing a home-based case that happened in their town, in their own district court, saying that this exact kind of sort of case already happened, and there was already precedent saying that even though the company wasn't roped in, the two key guys were. Therefore, the company is being roped in, even though the company isn't located here. It's still going to get tried here because this is where all those clauses were signed, and everybody agreed that this was all going to get heard here. That's cool. Here, too, the parties' forum selection clause is valid, and both Iron Mace and the individual defendants are entitled to enforce it with respect to all the claims asserted against them in this action. The court's sole remaining consideration is whether the public interest factors so clearly favor litigation in Washington that they constitute extraordinary circumstances. And then obviously they're going to argue we don't know what those extraordinary circumstances are. I don't even know what the fuck they would be. Unless they would claim like persecution, like Iron Mace is persecuting against Nexon in court or something. Like, how do you pull that off? Nexon's the bully. The private interest factors nevertheless weigh heavily in favor of dismissal. Even if the court were to reach the private interest factors, which it need not do under Atlantic Marine, the balance of private interests overwhelmingly weighs in favor of litigation in Korea as opposed to Washington. The private interest factors the court may consider include the residence of the parties and the witnesses. So, private interest factors, residence of the parties and the witnesses. The only person that has a residence in the United States is Terry. The forum's convenience to the litigants. Again, Korea being the most convenient place because it's already all in Korean. Everybody lives there. Access to physical evidence and other sources of proof. All of the evidence is in Korea. There's 10,000 pages of it, and it's all in Korean, plus all of the laptops and all of the servers and everything. The physical, like anything physical is in Korea already and is untranslated to English as far as I'm aware. Whether unwilling witnesses can be compelled to testify. So this is interesting too. That maybe it could end up being like an intimidation thing, where somebody's way more comfortable trying to talk about stuff in Korea, and then you have to get it all translated. Or if you're in the United States court, then you have to get a translator. Somebody has to like try and speak through the translator for the United States court if there's witnesses involved. The cost of bringing witnesses to trial, obviously there's a cost associated with that because even just with two court cases going on at the same time. The enforceability of the judgment, and all of the practical problems that make trial of a case easy, expeditious, and inexpensive. So what they're trying to say here is that in the United States, like if we could find them guilty, right? Or, enforce whatever we're going to enforce on them or say that we will. But then it's possible that in trying to get that enforced between United States law and then whatever goes on in Korea, that there could be like nuanced bullshit to argue back and forth over there. So maybe it's not really enforceable. Like we can shut them off here, but if you wanted to shut it off all the way, wouldn't you just shut it off at the source instead of trying to shut it off in each individual place where you're going to try and argue it? And 7, all other practical problems that make... Oh, yeah, we saw that. Okay. Plaintiff Nexon is a Korean corporation with its principal place of business in Korea. Iron Mace is also a Korean corporation. Choi is a citizen of Korea. Park has been living and working exclusively in Korea since 2005. Insofar as these individual defendants personally participated in blah, 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 Nexon alleges they did so exclusively from Korea. Neither Choi nor Park has ever been to the state of Washington. All of the conduct giving rise to Nexon's claims took place in Korea. Nexon alleges Choi misappropriated trade secrets for P3 out in Nexon's office in Korea to provide servers located in Chosin and Seongnam. I'm butchering the shit out of those names. Both in Korea. As alleged to the complaint, after Choi and Park left Nexon, 9 Nexon employees left Nexon to work for Iron Mace. Each of these employees resides in Korea, as all do the relevant Nexon employees. All the physical evidence is in Korea. The foregoing conduct was allegedly in violation of at least 7 different Nexon company policies and guidelines. Any acts or omissions giving rise to these alleged contractual violations would have occurred in Korea, where the individual defendants work and reside. Each of the documents at issue are in the Korean language. In connection with its Korean application for preliminary injunction, numerous supporting exhibits, all in Korean. Between Nexon and Iron Mace, the parties have already submitted thousands of pages of briefing and evidence to the court in Korea, all of which is Korean. Like it's just like everything is Korean. Because the events at issue in the complaint took place in Korea, the vast majority of discovery in this action will necessarily come from and take place in Korea. This is where both parties are located, the location of the relevant documents, and witnesses, to the extent the witness's testimony could be obtained in connection with the U.S. civil case. Pre-trial depositions of virtually every witness would have to occur in Korea through Korean English interpreters. In order to use any of the relevant documents in a Washington proceeding, they would need to be translated into English, and the translation certified as accurate. That would take fucking forever. Given that the parties in the Korean proceedings have already produced thousands of pages of exhibits, the cost of translating all the documents in this case could easily exceed hundreds of thousands of dollars, if not much more. Completely agree. The man hours to translate 10,000 pages worth of shit would be insane. Not to mention active translation of like verbal testimony. Holy God. Holy God, dude. If the cases proceeded in Washington, discovery and trial would likely involve an arduous process of securing the appearance of witnesses without the benefit of this court's subpoena power and transporting witnesses and evidence to the United States. Yeah, and then they're citing a case where this kind of thing had happened and it didn't make any damn sense. Affirming district court's finding that Korea was more convenient form than the chosen form of the U.S. So this is, again, this case talks about bringing people to the United States or all of the evidence involved and how time-consuming and expensive that would be, which affirmed the district court's finding that Korea was a more convenient form. I think they have a really, really hard-pressed case to try and argue that the United States would be somehow more convenient to hear this exact case than the home turf, especially since it's already going on. A Korean court, on the other hand, would face no such difficulty in compelling evidence from unwilling third parties residing in Korea. I mean, I have to agree. In light of these considerations, there can be no dispute that Korea will provide better access to sources of proof and the relevant witnesses and is a much more expeditious and inexpensive forum for the resolution of the parties' proceedings. Agree. A dismissal upheld in copyright action where design and manufacture of parties' computer software took place in Singapore. Most of the witnesses and documents were located in Singapore. Nexon has already demonstrated that Korea is not an inconvenient forum based on its ongoing participation in proceedings there, including filing for a motion of preliminary injunction. So, like, it's kind of hard to argue that the Korean court system doesn't do a good enough job if you're utilizing the exact court system to enact the provisions that you're trying to get enacted against the people that you're suing, right? You can't be like, well, you know, they done Korea, you know, Korea's Korea, though. Like, you know, the United States, you know what I'm saying? United States law. We don't want this thing offered up on Steam. You know what's really shitty about this, though? You know what's really, really shitty about this? Is that they don't have a verdict in Korean court yet. And the Korean court didn't file any temporary injunction or find Nexon in the right at all so far. But Nexon still filed a DMCA claim to get it removed from Steam. It is possible, and I don't know if this would even be remotely fucking true or not. It is possible that if the dismissal for this is granted, and I actually like, maybe there's a lawyer in the comments or something that will be able to chime in on this. I don't see a scenario where if this gets tossed, like, I mean, if they're like, yep, go to Korea. If this gets tossed, that means DMCA doesn't apply anymore. There is no DMCA claim. There's no more lawsuit. There's nothing more to litigate. There is no court case. If this gets dismissed, I think Dark and Darker goes back on Steam, dude. I think that happens. I don't see why it wouldn't. Well, no, they don't have to. That's the thing. Steam resides in the United States. Valve is a United States company, United States corporation. In order to get something delisted from a United States corporation's marketplace, like it is, you know, digital goods or whatever, they have to invoke United States law. It's in violation of the DMCA. They make that claim. They provide compelling evidence. We meaning like the general public, like let's say it's against somebody in the general public, like Nexon says Iron Mace bad. Iron Mace responds. they dispute it. The rule is they get 10 days to do the dispute. 10 business days, 2 weeks. They get 10 days to do the dispute. The dispute goes in. Then there's another 2-week period where Nexon has to file a court case. If they don't file a court case, Dark and Darker goes back up, right? The court case exists. They have to see the court case through. And then whatever verdict comes out, Steam goes, okay, satisfied the DMCA bullshit. Game goes back up on Steam, doesn't go back up on Steam, pending whatever the verdict is. If the court case gets tossed, there's no more DMCA claim. Dispute wins, right? Because they're disputing it with the marketplace. Marketplace is no longer liable if there's no DMCA claim on the books anymore. So I don't see how Dark and Darker wouldn't be relisted. Nexon can appeal. Yeah, sure they can. Yeah, they can appeal, but that's still not a pending case though. The appellate court isn't the same thing. Right? I don't know. I don't know how they handle the appeal side. I mean, a judgment's a judgment until the next judgment comes out. You know what I'm saying? I don't know. I don't know what the rule is. Like I said, maybe there's somebody in the comments that would be able to, shine some light on it. I need an IP attorney. The only connection Washington has to this case is incredibly attenuated. Nexon alleges the defendants made Dark and Darker available for 4 playtests on Steam. Steam is owned by Valve, which is headquartered in Bellevue, Washington. What Nexon's complaint does not disclose, however, is that pursuant to the takedown notice sent by Nexon under the DMCA, Valve removed Dark and Darker from Steam nearly 2 months before Nexon ever filed this lawsuit. That's true. That is true. Valve's location is largely irrelevant to the claims asserted against the defendants. Defendants are accused of misappropriating trade secrets in Korea and distributing an allegedly infringing game worldwide. Indeed, the only reason Nexon filed its lawsuit in Washington was because Iron Mace was required to submit to this court's jurisdiction as a condition of serving a DMCA counter notification in which Iron Mace vigorously disputed Nexon's copyright infringement claims. They were, strong-armed by their own system to have to file a lawsuit in the United States, or the DMCA claim would have failed. They had to do it. That's what I just said that. Declaration of Aaron J. Moss, that was his letter. But the fact that Iron Mace may be subject to personal jurisdiction in this court does not mean that Washington is a convenient or even appropriate forum to hear the parties' dispute, particularly given that the alleged conduct giving rise to Nexon's claims occurred exclusively in Korea. True. That's true. Nothing really ever happened in the U.S. There's no business dealing going on in the U.S. aside from Steam. Simply stated, there's nothing easy, expeditious, and inexpensive about having a Korean plaintiff and Korean defendants engage in litigation in Washington that is duplicative of proceedings that are already well underway in Korea. Therefore, even if this court were to consider the private interest factors notwithstanding the parties' valid forum selection clause, they weigh heavily in favor of dismissal. I agree. The public interest factors include public interest factors also weigh heavily in favor of dismissal. Okay. Local interest of the lawsuit, the court's familiarity with governing law, the burden on local courts and juries, congestion in the court, and the courts are resolving dispute unrelated to the forum. So these are the things that they take into consideration if something's going to get heard remotely versus locally. Most convenient, right? As discussed above, because the relevant conduct allegedly giving rise to liability occurred in Korea, there's no local interest in having this matter resolved in Washington. In confronting a nearly identical set of facts, the Court of Appeals in Creative Technology concluded that the public interest weighed in favor of dismissal. This is essentially a dispute between 2 Singapore corporations as to which one of them was the original developer of the disputed intellectual property. This is not a case involving the piracy of American-made products or substantively involving American companies. As such, the United States' interest in resolving this controversy and the relation of the jury community to this controversy are extremely attenuated and do not sway the balance against dismissal. Dude, Aaron Moss is a fucking attorney, dude. You know? Kind of like how the doc has that caterpillar on his lip. You know, he's got that poisonous caterpillar, but Sequisha's got a fucking mustache. You know what I'm saying? That's how this is. Aaron Moss is a fucking attorney. Retaining this action would impose considerable and unwarranted burdens on Washington and its citizens. whose tax dollars would have to support the expense of trying this case and whose time could be taken up by sitting as jurors. Gulf Oil Corp versus Gilbert. The jury duty is a burden that ought not to be imposed upon the people of a community which has no relation to the litigation. I mean, that's fair. That's fair. Right? Like, think about like the normal people that would be living around the Ninth Circuit Court that would get summoned to serve as jurors. Right? Like, yeah, you might get like a hipster or two, but the vast majority of the people that would be sitting on the jury actually hearing this case aren't going to know fuck all about steam. They're not going to understand any terminology related to anything that Iron Mace or Nexon has going on. They're not going to have any understanding of any of it. And to boot, then they're going to get told that all of this is going on in Korea. Like, if I'm a juror, I'm like, why the fuck am I talking to you about a Korean company? You know, regardless of where you come from. I mean, that's a solid point. The court would likely have to deal with foreign discovery issues, which will be time-consuming and potentially impose significant delays. I mean, there's no way it wouldn't be delayed. If the case proceeds to trial, there's also the need to assure the translation and testimony from foreign witnesses is accurate, which could impose significant costs on the court. The complexity of this case ensures that the trial will consume a significant amount of court and litigant time and resources and impede the ability of local litigants to try their cases in this district. I mean, they will live in a courtroom for this case for like 6 months. There's no way it wouldn't. Given the lack of nexus between the conduct underlaying this dispute and Washington, the crowded federal dockets, difficulties presented... All right, so now he's kind of laying it on heavy, saying that like the court's too busy. Difficulties presented by Korean-speaking witnesses and Korean documents and the risk of inconsistent judgments, it would be an inefficient use of judicial resources for this case to proceed in Washington. I mean, I kind of have to agree with this, though. Right? There's a lot of reasons. I mean, you're talking like translated stuff. It's got to be certified translated. Like he's saying, it's going to be time, time and money, right? On top of which, and then they're talking about the risk of inconsistent judgments, which means that like you could find in the United States court, they could find something like fine in one place, right? But then if it's still being tried over in Korea and the home base goes like, no, that's not fine. It's this way, or vice versa. Like you could have conflicting judgment shit. It should be dismissed in favor of the litigation proceedings that are already occurring between the parties in Korea, where there's a related action pending in an alternative form. Dismissal is favored to avoid a duplicative litigation and inconsistent outcomes. Jesus Christ. I should have been an attorney. You can see what they're pulling, right? Like, it's not hard to see where they're going with it. There are significant advantages in having all the parties assert their claims in one forum, not only to avoid inconsistent factual findings, but also to spare the litigants the additional cost of duplicative lawsuits. There's no need to litigate this matter separately in both forums, burdening a Washington court and jury with an action based on events that took place almost entirely outside of the U.S. And then declare this is a certificate of service, filed electronically with the court and served simultaneously upon all counsel of record. So they put this into the court and sent it off to all of the associated attorneys involved in the case, and signed by Aaron Moss and the local attorney Michael Chait. So Michael Chait was brought in as an attorney that actually has he resides like in the 9th district. His office is in Seattle. So I don't know who Yoon Jeon is. Yoon Jun Jeon. I'm butchering his name. I feel horrible because I don't speak Korean and I know that I'm not saying their names right. And I'm trying not to be like a fucking pig-headed American when I pronounce their names or try to. And a letter with subject, blah, blah, blah. And then he talks about on April 20th, he sent a counter notification. A true and correct copy is Exhibit A. I emailed James Blackburn, counsel for Nexon, with copy. Requesting to meet and confer regarding defendants contemplating motion to dismiss based on forum nonconvenience because I'm located in LA. And some of Nexon's lawyers are located in Washington and Korea. Propose we meet and confer telephonically. Counsels for the parties, on June 20th, counsel for the parties engaged in their telephonic meet. On the call for defendants with myself and my partner, Josh Geller. On the call for Nexon was Blackburn and his colleagues, James Lee and Oscar Ramallo. I explained in detail the basis for defendants contemplate a motion to dismiss. I explained that the instant dispute is controlled by forum selection clauses. I also explained that both the private and public interest factors considered by courts in these motions heavily favor litigation in Korea. Mr. Blackburn asked me to supply him with citations to some of the legal authority we were relying on, which I did. After taking the matter under advisement, Mr. Blackburn emailed me today and wrote, after further consideration of defendant's motion to dismiss on forum nonconvenience, grounds following our meet and confer yesterday, Nexon will oppose defendant's motion. Bruh. Of course they will. Chat, do you know why? Do you know why they will? There are two key words that come to mind. Two very key words that come to mind when they say that they're going to oppose the defendant's motion. Do you know what those words are? Teef Boy nailed it. Billable hours. Nexon has unlimited money. Billable hours. All right. Young John. Oh, this is the Korean attorney. Oh, he's their attorney in Korea. He's the one that initially responded. He's actually been involved with these guys the longest. Okay. Facts stated herein are known to be personally, and if called as a witness, I could and would testify. I've been practicing law for 19 years in Korea. I mainly specialize in IP, IT, and privacy law. And then he talks about his accreditations. I've handled more than 100 cases of IP disputes. Korea has a written constitution that establishes an independent and impartial judiciary. Korea has a 3-tiered judicial system. Court cases typically begin at the district court level and appeal to high courts and ultimately the Supreme Court. Court issues a summons, and they have to appear within 30 days. Civil litigation matters. Parties have the right to pretrial discovery. It takes place at court hearings where the parties may request evidence, including testimony, expert, and documentary evidence. The district courts conduct evidentiary hearings at which the parties are able to provide documentary evidence, testimony, and argument. Korea has an adversarial litigation system, and the parties are able to examine witnesses presented by the opposing party. Okay, so it's like he's trying to say this is very, very similar to United States court system. They're trying to, what they're doing in their statements in these declarations is talk about how there are parallels between the two courts so that the judge would be compelled to dismiss the case in the United States because the Korean court would do a good enough job per like how the United States would have tried it. Korean courts can grant various forms of relief, which I already talked about. They have a Copyright Act, they have a DMCA, and they DTSA, like their versions of them. Plaintiff in a copyright infringement action may obtain many different remedies, preliminary injunctive relief, et cetera, et cetera, et cetera. We talked about this already, and then these were the cited things in the motion. And then they talk about trade secret misappropriation, active litigation in Korea between the parties. Okay, parties to the U.S. litigation are already litigating identical disputes in the Korean court system. On March 31st, filed a lawsuit against Nexon. On March 31st, Iron Mace filed a lawsuit against Nexon in the Suwon District Court. The lawsuit seeks a judicial declaration that Iron Mace's video game Dark and Darker does not infringe on any copyright that Nexon may have in its so-called P3 game. On April 10th, Iron Mace also filed an application for preliminary injunction against Nexon's business obstruction. Specifically, it seeks to enjoin Nexon from sending takedown notices to third parties, such as Valve Corporation, claiming that Dark and Darker infringes on Nexon's rights. If Iron Mace prevails, Nexon will be ordered to withdraw the takedown notice it sent to Valve Corporation under the United States DMCA. There you go. On April 14th, Nexon filed lawsuit against Iron Mace, Choi, and Park in the Suwon District Court. That lawsuit asserts claims of trade secret misappropriation and copyright infringement against Iron Mace, Choi, and Park and seeks preliminary injunction restraining them from, among other things, publishing or distributing Dark and Darker, which they failed to do 2 days ago. Or on Friday, whatever it was. Yeah, on the 16th, they failed. True and correct copies of the parties' applications for preliminary injunction, which set out the parties' claims in detail, are attached to the declaration as Exhibits 1 and 2. As detailed in the two pleadings, the dispute involves Nexon's claims that Choi and Park, former employees, acted improperly, blah, blah, blah. Iron Mace, Park, and Choi dispute the allegations. Nexon has been served and appeared in the Iron Mace lawsuit. Each of Iron Mace, Choi, and Park have been served and appeared in the Nexon lawsuit. The parties have all been actively litigating the lawsuits already. They've already had multiple evidentiary hearings before the court, including May 3rd, May 24th, and June 21st. Yeah, oh wait, this was yesterday. This is yesterday when it failed. That's the news article that we saw. In the morning, they got heard, and then we saw the news article yesterday, and the injunction on the Nexon side of it failed. All hearings have now been concluded, and both parties may submit additional written evidence to the court until July 19th. In the lawsuit so far, this is the month. This is the month that they're being reviewed by a third party. In the lawsuit so far, Nexon has filed thousands of pages of briefing and evidence, blah, blah, blah. The evidence that Nexon submitted includes, by way of example only, copies of Nexon's employment agreements with Choi, Nexon's acknowledgement about company IP, Nexon emails, written witness statements, text messages, transcripts, oral conversations. All of this material is in Korean. And then they list all the documents that were signed. Nexon has filed copies of each of these documents in the Nexon lawsuit, and the documents are written in Korean. Exhibit 3, each of these documents filed by Nexon. 4, 5, and 6. Translated copies of the employment agreement signed with the verbiage that we've already talked about multiple times. Procedural considerations. Even if there weren't active lawsuits being litigated between the parties, it's clear that as a procedural matter, Nexon could sue Iron Mace, Choi, and Park in Korea. Iron Mace has its principal place of business in Korea. Songnam is a city near Seoul and is within the geographical jurisdiction of the Suwon District Court. Nexon also has its principal place of business in Songnam, Korea, and the Suwon District Court is the most convenient place for Nexon to litigate. Blah, 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 blah. So then there's the exhibits. We seek a trial judgment that purpose of application. Yep. So these are the applications that were submitted to the Korean court to get them to stop. Dude, this is a huge ass document. Oops. Oh, install a font pack because it's all like the lower stuff is all in Korean now that it's been rendered. And then I think this is the originating complaint that was made to the court. It's like a carbon copy. They basically took it looks, dude, this looks like they took the complaint that they made to the Korean court and then just translated it into English and sent it to the US. Okay? Ju Hun Choi Declaration. Yeah, as long as this case is pending in Korea, they probably won't be able to release it in Korea until it's over. But United States Steam is a different animal, right? Okay. I'm one of the directors. I'm a citizen of the Republic of Korea. I never lived or worked in the United States. I joined Nexon in 2012 as a programmer. All right, so this is interesting. Here's like an actual statement from them, like filed with the court. And I want to see like if there's timeline here. While working at Nexon Korea, the company, like, and remember, like, SDF is the guy that was like the driving force behind this game being made. He's the creative director. Dark and Darker and Project P3, when he worked for Project P3, are both like products of his brain, more or less. And Terry says as much from interviews, like my first interview when I talked about Terry, like, where's this company from? Like, who's doing what? All that. He said flat out, like, this game is basically FDF's brain baby. So I'm interested to see if there's a timeline that he lays out in this. I currently have no plans to visit the United States. I've never visited the state of Washington. I joined Nexon in 2012 as a programmer. Eventually, I became a director and participated in various other projects during that time. While working at Nexon Korea, the company's offices were located in Seoul, and accordingly, I resided in Seoul and Songnam to be closer to my workplace. I am currently residing in Songnam. Okay. When I joined Nexon Korea, I signed a written employment contract. The contract was proposed to sign a draft written by Nexon Korea as is. Okay, so this is the verbiage that they're talking about. Like, they're going to obviously cover their bases, talk about how it was taken as is. You know, you can't dispute this. It's a contract of adhesion. It contains a provision that all contract disputes will be handled in the Korean District Court. While working at Nexon, I signed the acknowledgement of company, blah, blah, blah. That's supposed to be handled in district court. I was the director of P3 project when I was in Nexon Korea. I participated in the P3 project with several Nexon Korea employees for less than a year. With many nearby projects being canceled, There were extreme pressures to meet demands from the management. However, the manpower they provided was insufficient compared to their goal and schedule. More than half of the entire project period had to be carried out with only around 10 people. Far less than 20 people, Nexon claims, was used throughout the project's life. So we know that this is reiterated a couple of different times where the director, they hadn't said his name in prior posts and stuff, that people that worked for Nexon or whatever had said that they were a skeleton crew and they needed more people, and that SDF was constantly complaining that they needed more engineers and they weren't getting them. Although it was more difficult to achieve the goal due to the reduced development efficiency caused by COVID-19 and lack of support, I tried my utmost to meet their demands. I won't disclose the confidential details of the project, but contrary to the original plan, the P3 project only developed into a first-person battle royale game using a medieval fantasy background. The P3 project did not incorporate the mechanics of escaping, a key feature of the extraction genre popularized by games like Escape from Tarkov. The P3 project is a different genre of game than the Dark and Darker that I developed later on at Iron Mace. Until I left Nexon Korea in July of 2021, there was no near-complete version of the P3 game. During my departure from Nexon Korea, I completely deleted all trade secrets or sensitive information that Nexon Korea deemed problematic, and I have not retained any such information to this day. All the Nexon Korea employees who participated in P3 worked in Korea and communicated with each other in Korean. They conducted all aspects of their work in Korean. The Nexon Korea executives who oversaw the P3 team were also located in Korea and communicated in Korean. Okay, after leaving Nexon, I founded it in October 2021, developed first-person extraction game, and with a fantasy setting, which eventually became Dark and Darker. To officially develop the game, we built a team of around 20 skilled veteran game designers, etc., etc. No one at Iron Mace accessed or used Nexon's trade secrets or other intellectual property. We developed it from scratch. In addition to our own creations, we also utilized legally acquired publicly available assets on Real Engine Market. We have records and receipts of this entire process. Iron Mace headquarters is located in the Republic of Korea. I'm not even going to try to do that. We have a little more than 30 full-time employees who all live in Korea. So they've been hiring through all of this shit. They must have gotten some good investors, dude. Because they haven't been making any money, but now they've got 30 guys. When I talked to them a year ago, they had 22. More than 30 people. Meetings related to the development of Dark and Darker at Iron Mace were conducted in Korean. Game development documents, including design proposals and idea memos, were also in Korean. The records of our creative development efforts clearly demonstrate that we independently developed Dark and Darker. The source code and its development records, which demonstrate the construction method of Dark and Darker, will clearly confirm that we developed the game without using any proprietary assets or code from Nexon Korea. Our internal team discussed and documented the programming of Dark and Darker, all in Korean. Any above records, all the documents will be kept in our office in Korea. Computer systems used to develop it are in Korean office. All my work is in Korea. I work from my home. Nexon Korea has filed lawsuit against me, Terrence Sengwa Park, and Iron Mace in a Korean district court, alleging that our work infringes upon their copyright and unlawfully utilizes Nexon's trade secrets. Nexon claims that in this Korean lawsuit are the same as those raised in the ongoing lawsuit in the United States. I mean, it's pretty much the same fucking case. Iron Mace has clear evidence to prove that these claims are false. Our progress in creating the game has been carefully documented and recorded, and from this evidence, it's evident how we developed Dark and Darker from the beginning. These pieces of evidence are almost all in Korean, and the key witnesses who can testify to this are residents of Korea and communicate using Korean. Huh. All right, Terry Park. And the man himself, Terrence Sengwa Park. Sending back my last order of copium. I don't think this is copium, man. I really don't. I don't think this is copium. I think that the case is going to get tossed from the United States court. And I don't know what the rule is when it comes to Steam handling something like this that gets tossed to like a third-party jurisdiction, because now DMCA wouldn't be recognized anymore. So I don't know how that gets handled. I don't know what they do. I have never owned real property in the United States. Wait, so hold the fuck. Wait, what the fuck? What the fuck? All right. So Nexon, now remember, when people file shit in court, okay, when Nexon files shit in court, when everybody files shit in court, okay, they always use verbiage that it is believed to be true, right? Under penalty of perjury, it is believed to be true that Nexon's original complaint, in their original complaint letter, in their original complaint to DMCA offices, one of the reasons why they argued that the case should be heard in the United States is because of all the business that was getting done in the United States, because Terry Park's job at Nexon when he was creating and working for and with Project P3 was to create a marketing system that was designed to target Western audiences. So it's no shocker that Terry is fluent in English and Korean, because that was the initial job that he had, was to try and market this effectively to Western audiences. That was his gig. But they also said that Terry has a permanent residence in California. Like it's always been believed that, based on what Nexon had said, and this is why I always say that you have to take this kind of shit with a grain of salt, because it's always got bias. Just because they use the words "it's believed that" doesn't mean it's fucking true. This is a perfect example, albeit a very small detail, that they said in their original complaint letter why they wanted the case to be heard in the United States is because one of the executives for Iron Mace lived in the U.S. and had dual residency in the U.S. and in Korea. But Terry says, I am a permanent resident of South Korea. While I was born in the United States, in Los Angeles, I moved to South Korea in 2005. I have been living and working exclusively in Korea ever since. I am married to a Korean citizen and have 2 children who are both born in Korea. I have never owned real property in the United States, and I have never visited the state of Washington. I do not have a residence in Irvine, California. I currently have no plans to visit the United States in the foreseeable future. I mean, I know that it's a small thing, but like, come on. I have worked in the video game industry my entire career. I started as a graphic designer and community manager in the early 2000s, and over the course of my career, I've worked as a game designer for numerous different games and gaming studios. In 2010, I was a founding member for a new Korean game development studio called ThingSoft. In that capacity, I oversaw development of numerous mobile games. In 2013, ThingSoft was acquired by a subsidiary of Nexon Korea, the plaintiff in this case. In 2018, Nexon dissolved ThingSoft, and I started working for Nexon directly. From 2018 to 2021, I worked in game development at Nexon on various games, all of which were canceled or shelved and never publicly released. So, what he's saying at this point is that working for Nexon, he had a lot of projects that he worked on, and they all got fucking canceled on him. So, it could be believed that while he was working on Project P3, the belief was they were just going to fucking shit can that one too. But I digress. There's the I digress for everybody, right? The entire time I worked at Nexon, our office was located in Seongnam, a city in Korea's, I'm not even going to try, near Seoul. I lived in Seoul near Gangnam Station, about 10 kilometers from the Nexon office. When I began working at Nexon, I signed a written employment agreement, blah, 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 okay? This agreement was drafted solely by Nexon and presented to me to sign as is. I do not have a copy of that agreement any longer, but I have reviewed the copy of Mr. Choi's employment agreement submitted in connection, and it looks to be the same as the one I signed. In particular, my agreement had the same clause stating that any dispute relating to the agreement shall be heard in a district court in Korea. During my time at Nexon, the lead game designer for a development project that we can call P3, I worked on P3 along with several other employees. Nexon claims the P3 team had 20 people on it, but for most of the 11 months of the project's life, there were far fewer employees assigned to work on P3. Development was slowed down in large part due to Nexon's mismanagement and lack of faith of the project. So again, and here's the conflicting story. Nexon alleges the game was greenlit. If you read Nexon's complaint, they talk about how this game was going fucking full, like it was destined for success. We are bringing this thing to market. It's going to make us $1 bajillion, right? They also said that there were 20-something employees, 20 employees, and then half of the team, right? We talked about this a million times. Half of the team leaves to go with SDF and Terry. According to SDF and Terry, for the vast majority of the time, they had like 10 guys working there, which means that it wasn't half the team that left. It was like the whole fucking team. It was probably all of the OG guys were the ones that walked, which also means that if there were people that had been talking about how this case was bad and they couldn't believe they would do such a thing, and, you know, Nexon's in the right, you know, like former employees of the project that are on other projects now that were making like these ghost written forum posts, like these anonymous forum drops talking about how they couldn't believe that they would do this and they definitely stole shit. There's no way they'd be able to make this game, blah, blah, blah. It's possible that the people that were writing that came in at like the 11th hour. They could have been there for like a month, maybe 2, and have no actual history of like all of the working time that these guys were putting into it. And all the guys that left were probably the OGs. They were probably the ones that were brought in at the start and got to see like the generations of the project, and then we're like, yeah, this is fucked. But anyway, it doesn't matter. None of that even matters, because what matters is whether or not they took files with them. Okay, I joined Iron Mace in October 21. Our goal at Iron Mace was developed an extraction game crawler, blah, blah, blah. From the outset, we hired a large and skilled team of designers. Because we were a small indie studio, we could work much more quickly than larger gaming studios that were slowed down by unnecessary bureaucracy and politics. I believe that wholeheartedly. I've been on both ends of that, man. Small teams get shit done because everybody sits at the table and you just go, how about this? Okay, cool, let's do that. And then everybody goes and they do their job. Instead of like, well, you know, the boss has got meetings up through Tuesday, so I'm going to have to get something on his calendar. It's going to take 4 days to get up there to talk to them about this thing. And then we got to see if like that's going to fly. He's probably got to go talk to fucking appropriations or some shit. You know what I mean? Like it takes fucking forever. Iron Mace is headquartered in Cheongnam, Korea. We have a little over 30 full-time employees who all live in Korea. Our internal team communications are almost all in Korean because I was born in the United States. I'm comfortable speaking English, speaking and writing in English, but the rest of my team has much more limited familiarity with English. When our team writes internal emails to each other, we do it in Korean. The team strategy meetings where Iron Mace planned out how to develop Dark and Darker were conducted in Korean. When we took notes about our development, that was in Korean. This is in Korean. That's in Korean. Everything is in Korean. The source code and programming notes showing how the game was built will also confirm that we did not use any proprietary assets or code from Nexon in building Dark and Darker. I mean, like, these guys are adamant about this, by the way. Like, when Nexon said, you stole from us, you have our source code, we know that you're using our source code, you're using way too many files of similar nomenclature and like all of this other stuff. Iron Mace literally turned around and went like, okay, so we'll have a third party verify it. We'll send them our source code. You send them your source code and we'll have somebody else review it. And Nexon was kind of like, well, we want to review it ourselves. Like in our, like we'll have our people review it. And Iron Mace just went like, no, that's not happening. So the moment that they said that, Nexon put in their complaint the whole part about like, ironically, Iron Mace doesn't want us to review their source code. And it was like, well, yeah, not by you, douche. Like have somebody else that doesn't work for you review it. We'll give it to a third party, no problem. They've always claimed that. And there's a difference in argument between like, they don't want a third party reviewing it versus, yeah, we wanted to review it and they said no. Teehee, trade secrets, teehee. Right? Different animal. Okay, the source code and programming notes, blah, blah, blah. To any extent of the above records and maintain hard copy, those would be in their office in Korea. The computer systems were used to develop Dark and Darker in Korea. In Korea. All of the work that I did in Dark and Darker, I did in Korea, either from my home or from Iron Mace's office. Nexon has sued me, Mr. Choi, and Iron Mace in a Korean district court, claiming that our work unlawfully used Nexon's trade secrets. These are the same allegations that Nexon makes against us in U.S. litigation. That's true. On March 22nd, 2023, Nexon sent a takedown notice under the U.S. Digital Millennium Copyright Act to Valve Corporation as a result of playtests of Dark and Darker. This also means that the court case in Korea was filed prior to the court case that they filed in the United States, because they would have filed the court cases that they did in Korea ahead of the DMCA schedule, because they didn't file the court case in the United States until after, like, 2 weeks after or whatever. Iron Mace responded to the dispute. A true and correct copy of this takedown notice is attached as Exhibit B. Blah, blah, blah. Valve removed Dark and Darker from Steam on March 24th. The game hasn't been on Steam since it was taken down. So when was the initial filing date for Pacer? Hold on. Date filed 4/14. So they filed this in the United States and Korean courts on the same day. That's insane. It's insane to me. Hitting them on both sides. The game has not been on Steam since it was taken down. Iron Mace has clear and overwhelming evidence that these allegations are false. The written evidence to disprove Nexon's allegations is nearly all in Korean, and the key witnesses who would offer testimony all live in Korea and speak Korean. And then they have all of the Korean documentation. And then here's the letter that was sent to Steam in response. And that's it. That's it. And all of this got served to their other attorneys. Yeah, so I don't think this is gonna stick in U.S. court, man. I think they got way too big of a pile. TLDR and Dark and Darker back on Steam tomorrow. Probably not that fast, but that would be nice. I think, like, the takeaways from this are, it doesn't matter in this case where the marketplace is, especially if there is a court that is comparable to that of the United States, at least in form and function and robust penalizing statutes and all this other stuff that they have already set in place with court proceedings that are, roughly in the same form and function as United States court, and has all of the, home base has all of the evidence, everything in its own language, all the witnesses, all the testimony. They have everything that could be possibly litigated is already located in Korea. If it's already all there, and all of the parties already agreed that it would be heard by one of the district courts in their home area, I don't see how the United States keeps this one on the book. And I also don't see how Nexon's attorney ends up saying we're gonna rebut this and we're gonna keep fighting it in the United States court as long as we can. Although I do see it. One, it's billable hours. There's no reason why they wouldn't want to keep billing the client. The second reason is because, aside from courts of appeal, I don't know how DMCA gets handled if a court case gets dismissed. If they agreed to dismiss the court case, that means that they wouldn't be able to appeal it, right? So right now, they're probably assuming that the case will be tossed based on the merits of the dismissal request. They will probably assume that the case is going to get tossed, which will allow them to appeal it. If they agreed to having it tossed, they wouldn't be able to appeal the judgment, right? Then that makes sense, right? That makes sense. But if it gets tossed, the question then is, does it get to go back on Steam or not? And I don't know what the answer to that is. Because, logic dictates, if you have a DMCA claim that you then have to take to trial or try to take to trial, you have to file something in court in order to make the DMCA claim stick, so that your opponent doesn't get to list their game on Steam and make any fucking money off of it, because that was the move. If that court case gets thrown out and you get told, go figure it out in Korea, there is no law that says that the DMCA claim has to continue to be honored if the court case gets thrown. My wonder is if they take it to an appellate court and say, we're going to appeal this, if Steam is still obliged to honor the DMCA takedown request. Or if they can just be like, well, it got thrown out, you got your judgment, we don't have to leave this up. My knee-jerk reaction would be Valve's attorneys would probably not want to take the risk on, trying to interpret safe harbor provisions for DMCA, and they would probably still keep it down if it did go to appeal. But that also means that the appeal would have to be super fucking timely, because if it's not, there would be another letter that Aaron Moss's office is going to end up sending to Valve to say, this got evacuated, it went to Korea, there's no DMCA ruling binding this having to stay off of Steam anymore, please relist the game. And I don't see how Steam would say no. I don't see how they would say no. But like, I'm just some schmo sitting in a chair in upstate New York. You know what I mean? Like, I'm not a lawyer. I don't understand process and procedure when it comes to those kinds of things. So but if they are slow on responding, like let's say if it goes to appeals, that Steam would still honor the DMCA takedown request because of the appeal being pending. The question then becomes like, how long until the appeal goes out before Steam feels like it's cool to be able to like let this thing fly? Because if I'm Aaron Moss and the judge grants this, within minutes, I would have a pre-written, pre-drafted letter to send off to Steam to be like, relist this thing. It just got a judgment. Here's a copy of the judgment. Judgment says the court case got dismissed. It's not being heard in the United States court anymore. Please relist our shit. Failing that, if they don't get the appeal up quick enough, or if it doesn't matter if it goes to a court of appeal or not, if this gets tossed, aside from that, one like little scenario, if this gets thrown, if they toss it out, if they dismiss the case and they say, go hear it in Korea, if the case gets dismissed, I don't see why Dark and Darker doesn't get relisted on Steam, because they're not invoking any United States laws anymore. Would your letter say, please relist our shit? Yeah, it probably would. Yeah. Yeah, from the office of Peggles and Mick Peggles, would say, dear Steam, dear John Q Valve, please relist our shit. Sincerely, Peggleson Esquire. But this is interesting. I mean, and I think they're right. I think they're right. Also, this part about like Terry never having lived in California, like never owning property in California and not having a residence in California is fucking hilarious to me. It's so damn funny. I love it.